Hello, I'm Alexander Jeffrey, a summer associate with the Clark-Esposito law firm. This presentation will be about understanding OFAC sanctions and compliance. Generally, we will discuss understanding OFAC sanctions, the two types of export licenses under OFAC, and avoiding sanctions violations through building a compliance program. First, we must understand what is OFAC and what are sanctions. A sanction for the export community is an imposed penalty for disobeying a stated trade regulation by OFAC or the Department of Treasury generally. Also, OFAC, the Office of Foreign Assets Control, is under the U.S. Department of Treasury, and it administers and enforces economic trade sanctions against foreign governments, individuals, entities, and activities. OFAC has jurisdiction over U.S. citizens, permanent resident aliens, Cuba, Iran, and transactions that have a strong U.S. nexus. In certain cases, OFAC may bring sanctions against transactions involving goods and technology that were produced or assembled in the United States. OFAC imposes a variety of sanctions programs. First are the comprehensive restrictions. Comprehensive programs block nearly all trade with the specified country. Many of these restrictions are embargoes, but some are merely very extensive regulations. The most prominent comprehensive programs currently are the sanctions on Cuba, Iran, North Korea, and Syria. There are also very strong sanctions programs relating to other countries such as Venezuela and Ukraine, but these programs are particularized to target certain events. Next are limited programs. These programs have guidelines that specify how to interact with the targeted country or economic activity. These limited programs may be established through exceptions in general licenses or a mandate for specific licenses regarding certain transactions. Last, we have list-based programs. Most OFAC programs and sanctions fall under a list system in which individuals, entities, activities, or regimes are added to or removed from a list of blocked individuals regularly. The lists are usually used to target very specific activities such as terrorism, narcotics trafficking, criminal organizations, piracy, human rights abuses, foreign sanction evaders, or particular regime activity. The most expansive list is the Specially Designated Nationals and Blocked Persons list, the SDN list. Other lists include Foreign Sanctions Evaders List, FSE list, or the Sectoral Sanctions Identification List, SSI list. Now we move on to understanding how OFAC controls assets in relation to these programs. Rejecting and blocking are two terms used to describe how an individual or entity should act if they come into contact with an entity or person being subjected to an OFAC sanctions program. Rejecting is a tactic that is used less often, but instead of completely blocking an individual or entity's access to interest, this tactic prohibits certain transactions. The targeted transaction type may be related to a particular activity or industry. On the other hand, blocking is the complete prohibition of any kind of transaction or access to an interest involving the blocked person or entity. Monetary transactions are the most common to be blocked, but in certain situations, the access to assets and items of interest have also been blocked. In the latter situation, if an individual realizes they are in possession of an item of interest of a blocked individual, they are tasked with blocking access to said item and contacting OFAC about the actions that should be taken with the item. Typically, a rejection is a single occurrence, whereas blocking of assets may be an ongoing event, especially if the individual or entity is being blocked from a physical asset that is under the control of the individual doing the blocking. As a note, with either scenario, the action of rejecting or blocking an entity must be reported to OFAC within 10 days of the occurrence. Now we have the two types of OFAC licenses. Compared side by side are the key elements to each type of transaction, which are necessary for understanding which of the two types of licenses will be needed for your transaction. For the general license, which is the much more commonly used one of the two, there is no permission needed. They are announced publicly, usually through legislation or on the OFAC website. Once declared, it can be used by anyone, and it may be issued with an exception that allows all transactions except the type specified. In regulations or sometimes a general license, there is an exception written into the legislation that expressly allows for a certain type of transaction or entity to be exempted from a restriction that is otherwise placed on an entity or country by the regulation. On the other hand are specific licenses. Specific permission is needed from OFAC to obtain one of these licenses. The grant of the license is not announced, and also, these licenses are granted on a very subjective basis. They may be used to conduct a transaction that was an exception to a general license. Very common specific licenses include travel to and business in Cuba, agricultural and medical activities in Iran and Sudan, and also the release of blocked funds, typically to collect money from a blocked person. When requesting a specific license, OFAC wants the requesting party to be as detailed as possible, listing every person involved with the transaction, the shipment terms, and the schedule, including the end use of the products, which may be related to the banks that are being used for the transaction and the payment schedules. Next, it is very important to understand how OFAC enforces the sanctions. Sanctions violations are held to a strict liability standard, so OFAC applies their tiered system as reasonably appropriate for the situation and increases the severity of the penalty proportionately to the extent of the negligent or blatant degree of the conduct. Typically, an entire business or corporation is held liable for the violation of a single employee, but a single individual can be held liable if the violation is extremely egregious. First, OFAC may take no action once a violation is reported. They may find that there is no actual violation or the violation is very minute. Next is a cautionary letter. There is clearly a violation, but is not severe enough to warrant an actual penalty. After, there's a finding of a violation. There's a clear violation, and an official finding of violation is posted on OFAC's website. So then it becomes public knowledge that a business or entity has violated a OFAC sanction rule. Next, we have civil penalties. Civil penalties are imposed based on statutory maxims and can range from anywhere from a couple $1,000s to hundreds of thousands. Lastly is a criminal referral. The violation is so blatant or egregious that it is referred to the Department of Justice for criminal prosecution. Next are the subjective criteria that OFAC uses when determining which punitive action they will take against a violation. OFAC has complete discretion in deciding which tier of punitive action they pursue against an exporter for a violation. OFAC takes into account a variety of factors but gives the most weight to how the violation was disclosed. The exporter could have voluntarily disclosed. The disclosure could have come from the blocking or rejecting report. There could have been an active investigation from OFAC. There may have been an on-site audit, or there may have been a referral from another agency. Alongside examining the violation's disclosures, OFAC also will examine the characteristics of the transaction, including the characteristics of the violation. This is whether the violation was willful or reckless, the harm of the sanction that was violated, and also whether there was voluntary remediation by the exporter coupled with their awareness of the violation. This may include the timing of the violation and how it took place. Lastly are the characteristics of the institution. This will be the business or the exporter themselves. This includes individual characteristics such as the size of the business or how they operate. Previous enforcement actions that were taken against the business's compliance program, and how up to date or effective it is. Also, future compliance and deterrent effect, meaning whether OFAC looks to make an example of the business. And lastly, cooperation with OFAC, whether the business tried to hide information or what was upfront about their disclosure. Now we will discuss how to avoid these sanctions violations. OFAC actively works with exporters to avoid violations. They highly recommend that every export business develop an extensive compliance program based around the common mistakes and frequent violations that occur when dealing with sanctions. Frequent violations include unlicensed exports, transactions with sanctioned countries, transactions involving SDNs, and interacting with a freight forwarder outside of OFAC's jurisdiction that commits a violation. OFAC also gives a list of common mistakes. These mistakes include human error, flawed screening, misspelling of party names, outdated internal systems, misinterpreting OFAC's regulations, inapplicable or expired OFAC licenses, and failure to update internal lists. Many of these mistakes and violations come from misunderstanding the licensing process or not paying special attention to OFAC sanctions programs. Finally, we will discuss compliance programs. A compliance program is an internal system in an exporter's business that is solely meant to avoid sanctions violations. OFAC offers these six concepts as absolute necessities for any viable compliance program. It is important to note that every compliance program will be different and should be tailored to the particular needs of the exporter it is meant to serve. The first concept is risk assessment. The compliance program should constantly assess high-risk areas of the business, taking into account the following factors of the business: business size and location, partner activities, customer base, the transactional processes, and the product popularity and use. Next are the internal controls. Relevant documents should be regularly reviewed through multiple general systems as well as specific systems when necessary to screen various export transaction factors. These factors include the buyers, sellers, shipping companies, the final buyer, manufacturers, and forwarding agents. Even though OFAC gives an expansive list, this may not be exhaustive for some of the export transactions that involve a wide network of responsible parties. Many exporters have electronic systems in place to catch blocked individuals or entities that may be one of the parties. The next concept is internal testing and auditing. A business compliance program should be tested on at least an annual basis. Evaluating the effectiveness and identifying deficiencies will allow the program designer to remediate any outstanding issues that will lead to a violation. OFAC encourages businesses to use a third party to audit and test their compliance program and to immediately report if there are any glaring flaws that will most likely result in an unnoticed violation from the past. Next is a management team. The program should designate positions for employees that will manage the various aspects of compliance alongside the controls, testing, and auditing. OFAC highly suggests that this team and the person who audits the program should not be the same person who designed and implemented the compliance program. Then we have training. All employees should be made aware of the compliance program in place with the business and the broad concepts of how it operates. Employees should also be aware of how to use the system to check for a blocked person, or who can be referred to for assistance with doing so. Every new employee should be given training specifically relating to how to utilize the compliance program. OFAC also suggests annual refreshers for all employees. Lastly is program flexibility. The program should be able to be updated regularly and would ideally update itself when new lists and licenses are issued. This is very important as the high-risk areas in a business may shift as new licenses are issued or as the business itself experiences internal structural shifts. The program should also be intuitive so that if there is a new management team, they will be able to learn the system with little to no confusion. In summary, we discussed OFAC sanctions, the two types of export licenses under OFAC, and avoiding sanctions violations alongside building a compliance program. Here at the Clark-Esposito law firm, our goal is to help streamline the global business operations of importers, exporters, and the companies that support them. So if you have a question, don't hesitate to reach out to us. Thank you for viewing.